All right, welcome back to the program. In case you're just joining us, it's time for our conversation right now. At the beginning of the show, I did tell you that we'll be looking at the new CAMA law. My guest is joining me right now via Skype, Toyin Bashir, who is a partner at Banwo and Ighodalo. Welcome, ma'am, and thank you for joining us on the show today.
Thank you for having me.
Okay, let's get started. I know that this new CAMA law is a huge document. It has 870 sections or provisions. For those of you that are lawyers, it may not be too difficult to study. But for the benefit of our viewers, can you quickly just take us through the summary of what this new CAMA law is? Of course, this new CAMA law is coming after 30 years the old one was enacted.
So I'll do my best in summarizing what you have described as a huge bill. And I think probably the best way to do that would be to, lean on the broad objectives of the review of the bill itself. That is the broad objectives of the review of CAMA 1990. So one of the objectives at the time of the review was that it was important to have provisions which support setup and operation of companies. So in that regard, we have a lot of provisions which essentially supports, SMEs or Nigerian businesses or even international businesses from setting up businesses, registering companies in Nigeria, as well as provisions around the operations of the companies and just generally how you can structure your articles of association, which is a document which guides the operations of a company and the sort of provisions that can be inserted in that document which supports doing business. Also, one of the broad objectives was to ensure a more appropriate regulatory framework for MSMEs. So MSMEs was top on the list in terms of we need a business law, we need to review our business law, and the role of MSMEs, of course, cannot be overemphasized. So it was important that we looked at basically best practices, look at our current situation in Nigeria, what could be helpful for MSMEs. And that's why we now have a particular legal framework which supports SMEs by exempting them from what was perceived as onerous compliance obligations. So, obligations like the appointments to the mandatory requirement to appoint a company secretary, an auditor, exemptions from, holding annual general meetings, even the redefinition of a small company itself, starting from the redefinition of a small company to allow more SMEs to come within, that definition. Also, to enhance transparency, shareholder engagement. So we have a lot of provisions around disclosures. You have disclosures of conflicts of interest, for instance, in relation to directors. Previously, directors would only disclose conflicts at the next board meeting or the following one if they were not even able to disclose conflict of interest. But now there's an immediate requirement for directors to disclose conflict of interest. So that is if they have an interest in a transaction or even a proposed transaction, they're expected to immediately notify the company in writing. So there are also disclosure requirements around, beneficial ownership, substantial shareholders, things about putting in accounts on a website. All of these things we support transparency, and we all know that when we have a more transparent government, generally, it also provides investor confidence in Nigeria because of the perception as well. And so those provisions basically support it. Also to align the provisions, in line with international best practices and old law. It wasn't in tandem with current realities. It was definitely, you had to look at how things were being done elsewhere because Nigeria is not a standalone, it also operates in the international space. So in line with the international sort of transactions that have now started happening between when the law was passed 30 years ago and what is now, and even looking forward to the sort of transactions that will take place in the next couple of years, at least until CAMA is again revised. So there are a lot of progressive provisions in relation to also transactions, so specific transactions like mergers, inserting provisions which essentially support business. And then the last thing was to enhance regulatory operation, and of course the regulator in this case is the CAC, things that enable them to use technology. Even the action of pre-registration where you could register on their portal wasn't supported in the old CAMA. But now you have provisions which basically support the introduction of technology for pre-registration, post-registration, in terms of all the filings that companies have to make after they have been registered. So just leaning on those broad objectives, it covers those areas. So there are provisions which essentially support all of these broad objectives.
Okay, let's start. Has the law been gazetted yet? Because it's supposed to be gazetted before the commencement, isn't it?
Yes, it's supposed to be. It's not yet gazetted. I myself have been consulting with the Registrar General of CAC. I know also that it's in works at the National Assembly. And I guess it's all of the issues around, some of the processes that they have to undertake. And then because it's also a very large bill, it's important that it's done properly. But I hear it's in the offing. So, I think the Registrar General had speculated that by October 1st, we should be in a position they would be in a position to announce that it's been gazetted and then it has come into full operation. So we'll see how that goes.
Okay, Professor Olawale Ajai is also joining us on this platform. He's a professor of legal, social and political environment, Lagos Business School. He's also joining us to speak about this new CAMA law. Professor Ajai, are you there? Okay, let's continue the discussion with Toyin Bashir, who is still there. You actually did mention earlier that this new CAMA law seems to define what a small company is. With this new CAMA law, what is a small company within the context of this new CAMA law?
Okay, so previously, the small company was essentially a company that had basically net assets of turnover of about 2 million and then net asset value of about 1 million, I believe. But now it has been reviewed that a small company is now a company with turnover of 120 million and then net assets of about 60 million. And in essence, the broad objective was to ensure that a lot of MSMEs then qualified to be described and treated as small companies, because the previous provision was so small as to exclude quite a number of MSMEs from the description, and then again, of course, the attendant benefits that would accrue to such small companies under the provisions of CAMA. So that was done essentially to bring them within that. And I think one of the things that I don't know if it's appropriate to mention at this point is one of the controversies that I have heard people mention is in relation to the provisions of the Finance Act in relation to small companies. So there's been some kind of call to CAC to probably review, the thresholds that have been prescribed in CAMA, just because the Finance Act, basically describes, a small company as one with 25 million naira, turnover. And so as a result of that, they felt that there was an inconsistency. And then the fact that also when you're filing your tax returns, you're expected to annex your financial statements to it. So every company is expected to do that. Small companies under the Finance Act have been excluded from corporate tax under the Companies Income Tax Act. So it was the revision of that particular law. But you see, I think that it's important that we don't toss out the baby with the bathwater, because one of the provisions under the exemptions for small companies in CAMA is that you don't have to, appoint an auditor. But then there's several other exemptions and several other benefits for small companies. So even if in practical terms, a small company probably has to have an auditor, because in filing its tax returns, it has to file financial statements. But it's just one of the exemptions. And then even at that, you just need to appoint an auditor to do that particular process, as opposed to CAMA 1990, where it was a mandatory requirement that you must have an auditor in your books. You must appoint an auditor at every AGM. So it was some sort of a retainer kind of arrangement. So on that basis, I'm really hoping that the CAC isn't considering that, because the draftsman actually included those revisions to ensure a lot more MSMEs were covered, because it was also identified that for every economy to grow, in essence, you have to support the MSMEs. And that's the only way you can then get real growth in an economy.
Hello YouTubers, welcome to Moneyline with Nancy TV YouTube channel. This is where we provide you with instructive business directions, processes, and guidance to help you assess the right resources to fund your businesses to withstand every form of internal and external shock. You will find here awesome informative videos on business, entrepreneurship, and lifestyle just to help you make informed business and financial decisions. Punch the subscribe button and let us drive you through the world of business. Please follow all our social media platforms on Facebook, on Twitter, on Instagram, on LinkedIn, and follow us for latest updates on our website. Okay, let me bring in Professor Ajai right now. I'm being told that he's ready for us. Prof, if you can hear me, under the old law, we had three legal entity types. I think companies, we also had for business names and incorporated trustees. But with this new law, we have what we call limited liability partnerships and partnerships. Please, can you just quickly explain to our viewers what this means and the implications?
Thank you very much. It's a pleasure to join you. Well, a limited liability partnership is basically a partnership with limited liability. Ordinarily, in the law, partnerships are individuals who join together to do business, and the liabilities fall on them as individuals. In other words, they have unlimited liability. But in a limited liability partnership, they are partners, in other words, they haven't dissolved, so to say, into a company that's an entity. They bring in their shares, but they have the benefit of incorporated companies of limited liability, which means that if there should be losses, those losses will ordinarily be settled from the assets of the partnership rather than their own personal assets. So that is what a limited liability partnership is. So for tax purposes, it's still the partners who bear the tax. This enables what you call a lot of special purpose vehicles, big ticket items to be done. So you can have a company, or you can have several companies come together in a partnership, maybe for a particular venture. And after that venture is over, they can very easily just unwind and unpack and go away without going through the intricate provisions of winding down if they had been incorporated as a company. The only point is that the law requires that at least two individuals should be designated partners who will be responsible for the compliance requirements of the Act and for any liabilities that that may be imposed on the limited liability partnership. Of course, partners who are fraudulent or who commit crimes, cheat creditors or suppliers will bear responsibility for their own misdeeds. So that is what the limited liability partnership is. You can have professionals, for example, come together and they can also have the benefit of that limited liability. So, you also have the limited partnership. So normally, in the normal law, you normally have you could have a limited partner, but there must be some general partners. General partners bear liability of the partnership. A limited partner normally is allowed to contribute to funds to the partnership and not to take part in the running of the partnership, so that his liability will be restricted to whatever amount he contributed to the partnership. Limited partnerships can also be registered under the new act, and the same thing. Limited partnerships also allow for what's it now? Big ticket items, construction, films, special purpose vehicles. You can have a company, for example, invest in a startup, and that startup could be a limited partnership. So the investor could be a limited partner, and the other chaps, they don't have to go through the intricacies of company formation. So that is that really is the beauty. It brings a bit of its versatility into the picture. The only funny thing, well, not funny, one of the things, a change in the law is that whereas under the old law, a limited partner must not take part in running of the company, the CAMA 2020 gives a limited partner an opportunity to give some advice. We don't know how this to play out in the court, but that is the change that one can notice in the limited partnership.
Okay, Prof.
Registrable under the new act.
Prof, can you also speak to us about the introduction of a single-man company, of a one-man company? Because even in the old law, to introduce a one-man company, you still need two people, at least. But this is quite interesting, and this is, I want you to explain this because, like I said earlier before you joined us, we have 41.5 million micro businesses in Nigeria. And most of these micro businesses are one-man businesses that hire 2-3 people. So this is quite key. So how will this really impact on their businesses, and what is expected of them from this new CAMA law?
Well, yeah, so essentially, really what it means is that the one-man business can incorporate and, have the benefit of limited liability. In other words, if he trades and makes losses or horrendous losses, he wouldn't have to sell his shirt. He wouldn't have to bring his personal assets in order to default. Portfolio company you can go and register as a single shareholder, or rather than looking for an additional person, and you can have one director. So essentially what it means is that you now have the opportunity to trade other than through the business name. You have the opportunity of incorporating, and the benefit of limited liability. And I think I heard Ms. Bashir mentioning that there are some exemptions which will make it easier for someone at that level to operate as a company. You wouldn't have to file, some of the requirements for bigger companies. You don't need to appoint an auditor. You do not need to appoint a secretary. You do not need to hold an annual general meeting. The law seems to say that even the CEO does not bear responsibility for the accuracy of audited reports. But I think the truth is that actually the law, I think, provides a sliding scale. So you can come in, as I mentioned, that one person alone or one person with a few employees, and you can have the benefit of incorporation and limited liability. However, the truth of the matter is that you will need to house it, probably access loans. You may need to assure suppliers at that stage. When your business gets to that stage, you will need financial statements, and those financial statements will need to be, to be credible. And you probably will need an auditor. So I think the law very ingeniously provides for some sort of a sliding scale, so that as you sort of grow in terms of the value of your business, you will then, some of the requirements that assure investors creditors, that your business is sound and can repay whatever credit they have given you, you will sort of need to make that available. Indeed, when you look at the schedule to the Act, when it talks about financial statements for small companies, when it talks about returns for small companies, it does also require them, at least it puts in there that they need to have financial statements, audited statements, and so on. So whereas in the substantive section, that is not required, but as you get to that stage, you will, of course, need to go through those motions.
Okay, I'll be coming back to Toyin in a bit, but Prof, let me stick with you a bit. From what you said about the single company issue, do you think that we can see a bit of shenanigans coming in from micro businesses as it regards this single company? Because there are a lot of things that have been left, you know, they've been given a lot of leeway. Would there be cause for some kind of transparency issues? That's the A part of the question. The B part of the question is, for companies that are single-owned businesses or one-man company businesses that were ab initio registered with the CAC, but having two shareholders, but as a single company, you know what I'm saying, because it was law, people would just have to go and register, bring in your brother or bring in your sister, just be a director, and that person does not even know what the company is doing. With this law now, can people in that category actually, you know, re-register? Was there any part of it? That's just what's going in my head.
What?
Perhaps as a businesswoman, can I go to CAC and re-register and say Nancy and Company, that was perhaps two people, and I just want to be Nancy Business or Nancy Limited? Prof, are you there? Okay. Okay, we seem to be having technical difficulties. We seem to be having technical difficulties with Prof. Let me come over to Madam Toyin and ask you, I will leave that question for Prof, except you really want to comment about it. But let me also go to this matter, which when the CAMA law was signed, a lot of controversies came out from the religious organizations about trustees and what have you. Would you mind to clarify that?
Thank you, Nancy. I will leave those questions. I'll be happy to talk about it, but I'll leave those questions to Prof. And if we don't get him back, then I'll speak to it.
Yes.
So in relation to, so that's been really controversial, right? There's nobody in Nigeria that is not aware. I was at the supermarket, I was at ShopRite the other day, and at the till, they were talking about it. I couldn't believe it. They were talking about CAMA, the man at the till and somebody else who was the guys that push the trolleys. They were talking about it, so it's been highly controversial. And I think it's important to also clarify that those provisions, firstly, those provisions don't apply to only religious bodies, because that has been the main conversation around the religious bodies. It's for all associations which are registered by the CAC. So these are companies that are recognized as persons. They have commercial transactions as a result of this registration. So at some point, in my own view, in some point, we have to look at regulation. We also have to look at the trend in the world. A lot of people collect and receive monies, and which are supposedly for specific objectives, and they don't apply it to those objectives. It is a reality. And that's what society is. Society continues to evolve. And when you see issues, you try to then provide solutions to resolve those issues. And so borrowing from a different jurisdiction like the UK, because the Companies Law was formed around the Companies Act in the United Kingdom anyway. So borrowing from the provisions of the Charities Law, minimal provisions, I must add, they're not even the extensive provisions in the Charities Act, taking away minimal provisions that they have seen that has worked in a similar jurisdiction and bringing it to Nigeria. and then not making those provisions or those powers absolute to CAC. So you have the courts also providing the balance in terms of the checks on CAC. Indeed, is it true that there's some organizations or some associations that are involved in misconduct or misappropriation? Yes, they are, and it goes beyond religious bodies, like I mentioned. Even associations in terms of some certain associations which receive monies from international organizations and even local organizations. We have the Dangotes and the Toyin who have endowed funds for certain, whether it's poverty alleviation or a particular target issue in the society, and they give it to these smaller associations to execute. Are those monies being used for the purpose or people using it to build houses and buy cars? I think it's right for us to have that kind of power in the regulators. I appreciate the noise. I think the noise would have the effect of keeping the regulators on their toes. At least they know that Nigerians are watching. So I imagine that they would use their powers judiciously and also in a transparent manner, so that when there are those petitions to CAC alleging misconduct, alleging misappropriation or misuse of funds which were supposed to be directed to the objectives, and CAC investigates, it will be a process we will probably all see, because this is a public organization, and that is the CAC. There's nothing that will be hidden. So I applaud it. I think it's something that we should give time and let's see how it evolves. I think that it's important to have checks and balances in every aspect. If the companies who are investing monies are regulated, private companies who are investing their own personal monies, I'm not even talking about public companies, but even public companies, if they are regulated, I absolutely see no reason why non-profit associations cannot also be regulated to some extent.
Okay, let's talk about the issue of registration of charges by companies, because I think with this new CAMA law, it's not supposed to exceed more than 0.35%. Okay, I'm being told we have Prof back, and I need him to answer that question because we have just a few minutes to go. Prof, can I see you so that you can answer those questions which I posed earlier? I hope you got those questions before the network got frozen.
Well, I did hear you, but I think you were asking whether a company might want to
re-register.
Yes.
Well, then the second part of the question is the transparency issues with all this leeway that has been given for small businesses.
Right. Okay. What I would even say is that ordinarily, as I did mention, likely to want to be a single shareholder or one-man company when your business is relatively small. But as your business grows, as your custom increases, and suppliers, customers want to look to, want to have some assurance that the business is being properly run and the business is transparent, you are more likely on your own going to want to show that it's not just a one-man show. What I would say is that yes, you could probably want to come down, but it's probably much better from a commercial point of view that you want to show that there's more than one head, there's some measure of accountability, there's some measure of transparency. So I think that is probably the better way that a commercial person is really going to behave. As I did mention, even though the law seems to give you the opportunity to do everything in-house and in your sitting room, but from the reality of commercial life, the likelihood is that you will have to file. What's it now? You still have to do your returns, even as a small company. You probably want to access loans. You want to get business. And so it's likely that the push to show more transparency, more accountability will move small companies in that direction.
Okay.
And one hopes that CAC will also help, and other bodies will also help them move in that direction.
Okay, very quickly, Madam Toyin, just speak about what I asked you earlier. The registration of charges not exceeding more than 0.35%. We'll have less than 1 minute to end the show.
Okay, okay then. I mean, so the one around the registration is really around registration of charges, and this applies to loans, and companies take loans all the time, and so I guess the cost of borrowing has been reduced as a result of this, because it was usually the borrowers that had the obligations to pay for the registration at the CAC, and it was a lot of money. So you can imagine borrowing money and then you have to pay a percentage of that still in terms of registration fees at the CAC. So one of the things that is absolutely a very welcome development was the reduction to 0.35%. I mean, that is amazing, because this is one of the cases that when we're very shocked when government basically basically reduces the cost of undertaking a particular process. So this is a lot of cost saving for the borrower. And just before the minute is up, I just also wanted to mention that in relation to the one-man company, you can file a change of director, so the second director can resign, and then you be the only one. And then if the person has shares, they can transfer the shares to you as well, and you can file those changes at the CAC, so you don't have to be registered. That company can continue to operate. Yeah.
I needed to ask that question. Thank you very much thank you very much to you both for joining me on today's edition of the program. So many provisions, 870 of them. We cannot speak about them within an hour, but I promise our viewers will continue to look at that. Thank you very much. I've been speaking with Toyin Bashir, partner at Banwo and Ighodalo, Professor Olawale Ajai, Professor of Legal, Social and Political Environment, Lagos Business School. Thank you for watching our video. Please hit the subscribe button below, turn on post notification to follow all our updates.